is Tom. I'm Tom Paul, the General Editor of the Modern Law Review, and welcome to this year's Chorley Lecture. It's a great pleasure to introduce our lecturer tonight, Professor Susanne Baer. Susanne Baer is, as many of you will know, Professor of Public Law and Gender Studies at Humboldt University Berlin, and also Leah Bates Global Law Professor at the University of Michigan Law School. From 2011 to 2023, Susanne served as Justice of the Federal Constitutional Court in Germany. A corresponding Fellow of the British Academy of Arts and Sciences here in the UK, where she gave the Maccabean Lectures in 2019. Professor Baer has also received honorary doctorates from Michigan, Hasselt and Lucerne. The only thing that I need to say tonight is further the title of the lecture, which is What Judges Do and Should Know. Thank you very much.
So imagine you're a judge at a Supreme Court, a Constitutional Court, a Human Rights Court. New files on your desk. You open them, you start reading. There are studies on both sides, to attack the statute and to defend it. They look pretty much the same. How are you to decide? This is the question that drives this lecture. But first, thank you so much for the invitation, really. It's truly an honor to be invited to give the Chorley. Ambivalent as it can be, expectations are high, I sense. And after all, it was Nikki Lacey last year on how to institutionalize interpersonal ideas in law to make it work in life, no less. So what is there to add? You took the risk, so thank you all for coming, especially my friends from the bench, Lady Hale, Lord Sales, and certainly David Kershaw, the Dean, the colleagues here at LSE, researchers, students. I know you came for drinks and dinner. I'm really sorry you have to go through this first. It is indeed about nothing less than the truth, the whole truth, which seems to slip away because truth is in crisis, or more precisely, knowledge is systematically undone. The question is then, what does that mean for the law, for courts, for judicial review in particular? And the argument is to not only take the law, but also take facts seriously, to deal with what I'm going to call the anti-factual challenge. It is not an entirely new question, knowledge or truth in law, but is an urgent one. It is also not a petty concern, and it's not just a legal one, because the question of facts, of knowledge, of truth, and the law, the handling of extra-juridical knowledge in constitutional adjudication is a question for those interested in socio-legal studies. So I thought it's an okay topic for the Chorley Lecture. After all, in 1972, H.L.A. Hart talked about nothing less than the demystification of the law. I'm all for it. A bit more radical, Roberto Unger, in 1995, rejected rationalizing legal analysis with its institutional fetishism as rather limited and frail, to seek an alternative in legal thought without adjudication. Well, I don't know about that. Reading the Modern Law Review, sure, to prepare, it became pretty clear to me that Chorley lectures have not ignored my question either. The changing conditions of knowledge, including data, of truth, of the law. In 1999, Kate Orsmal described the South African practice of the Truth and Reconciliation Commission, an alternative way to dealing with facts, including colonial trauma, and that is still a challenge. In 1998, Anthony Giddens discussed Beck's Risk Society, a description of a world of insecurity, last not least because of a lack of knowledge on many fronts. But this was then. Times, I think, have really changed. So what is now? Chorley lectures also dealt with the other part of my thoughts today, and some even targeted, I'm afraid, I'm unhappy to say, judicial review, which is something I will defend as indispensable for a democracy that deserves the label. In 2000, you were generous enough to invite another German, the then president of the German Federal Constitutional Court, Jutta Limbach, who talked about the concept of the supremacy of the Constitution. In 2011, Kate O'Regan, former judge at the South African Constitutional Court, reminded you to not forget about the text. And somebody called Thomas Poole, I think, took some well-established criticism of constitutionalism to the empirical test to show that proportionality rulings in the House of Lords did not lead to exaggerated uses of power. Indeed. But it is, as you can see, a contested field. And the question here is, what happens to judicial review when confronted with the anti-factual challenge? What is the role of courts when facts, expertise, knowledge, the truth are in a precarious and an endangered state, eventually eroding democracy? Courts must apply the law, yes, but accept which factual claims? How should Supreme Constitutional and Human Rights Courts handle facts, knowledge, the truth when facing that challenge? Not a new question, but urgent, because epistemologically things have really changed. I saw it in my files. When I served as a justice of the German Federal Constitutional Courts, the facts, the law was interesting and challenging enough, but the facts were decisive in the climate case, in the COVID cases, in all gender rulings, and more. In the UK, think of the facts that made you go to war against Iraq. Think of the facts in the Brexit campaign, or what is now dubbed gender war around transgender rights. In all these cases, the law is complicated enough, but facts really matter. So what do and what should judges know? How do they know things that come before them? What to accept as true or false, presented by government and other parties? This is difficult. It bothered me as a justice of the court, as it bothers other highest judges around the world. And there are others out there who worry. Let me quote a young Iranian, Nourin Akhtar, who posted this question online. What is justice in a post-truth world? Justice, she says, justitia, cannot any longer be a figure with a pair of scales and certainly not blindfolded, but has to now see through the digital smog of deceptions, masked as facts and noise, masquerading as knowledge. How can this be done? Akbar says there's a crisis of knowledge, a crisis of truth, what I call the anti-factual challenge. And what does this mean for the law? As much as the rule of law is the grammar of democracy, I think we must confront the question, how should courts deal with, uncover and reject beliefs, assumptions, lies in a polarized, triggering, indeed wild world? We do not have much time to find an answer. The truth did not just slip away from us on its own, the post-truth kind of condition. Rather, it is kicked around, it's beaten up, it's mobbed, it's, sorry, excuse the language, shitstormed out of our minds aggressively. And this is done by people I will call the new totalitarians, out there to destroy democracy, out there to destroy fundamental rights, out there to destroy the rule of law. So that is why the time to think about these questions and find answers is now. What is the role of courts? How about the culture of justification? How should judges, lawyers, academics, all of you, deal with the anti-factual challenge? I move in 3 steps. First, I'm going to describe that anti-factual challenge a little more precisely because we need to understand what's going on. Second, the law. How does the law react to it generally? Because there are many, many different practices out there, areas, etc., etc. And third, specifically, judicial review. How are we to think about courts under these conditions? What is the challenge? What should we do? So, we do not live in post-factual times, but with a severe anti-factual challenge. It's a highly polluted environment. Truth, facts, expertise, reality tends to get lost, and this is not new. In 1943, George Orwell commented on fascist propaganda. He wrote, "This kind of thing is frightening to me because it often gives me the feeling that the very concept of objective truth is fading out of the world." 1943. Also, philosopher Hannah Arendt, herself a close observer of German fascism, said that lies are, I quote, often used as substitutes for more violent means, and thus are apt to be considered relatively harmless tools in the arsenal of political action. But an extreme contempt for facts is essential, she said, to the rise of totalitarianism. And today, I think contempt is back, and some saw it coming. In England and Germany, post-truth was the word of the year in 2016. There are tons of studies out there that describe the decay of truth, one titled in 2018, A Truth Crisis in 2021. Ex-US President Barack Obama called it an epistemological crisis infecting all politics in 2020. So I think we need to really understand what is going on there. It is a crisis behind the crisis. The financial crisis, the health crisis of the pandemic like COVID, the climate crisis, last not least war, wherever, the crisis behind the crisis is the crisis of facts. We do not agree anymore. Why, what, who, when, what's happening, etc., etc. The truth about, say, international finance, the truth about the virus, the truth about injections, those shots, climate expertise, who knows, war, or is it a military operation, self-defense? Sources cannot be verified, you read in the news these days, but what are then the facts in case a court has to decide? It is indeed, in addition, a paradox, because there's so much data out there, so many facts. We know in some ways more than ever, but we do not know what information to trust anymore. It is not knowledge, but belief that becomes decisive. Facts are there, but they may as well be manipulated, fake, false. And this is therefore not just another struggle over meaning. Our shared epistemic foundation is eroding, if not gone. And this is extremely uncomfortable on several counts. Economically, post-industrial societies have been described as knowledge societies. And much effort goes into education and study and training and research and information management and all that. But when knowledge loses its standing, what then? Is it then deals about ownership and nothing else? Politically, democracy suffers. The less ability we have to agree on facts to then discuss what to do about them, the less legitimacy. A discursive community and communicative action, as Jürgen Habermas or Sheila Ben-Habib and those philosophers would have it, or a system of communication, if you follow Niklas Luhmann and Günter Teubner and others, or the idea, very prominent, of democracy as a marketplace of ideas, they are all based on a commitment to truth, information, knowledge, fact. When this is gone, democracy on all these counts becomes a fake performance. Are we thus bound, and this is what a German sociologist Helmut Wilke suggested already in 2002, to dystopia? Democracy did certainly not turn into expertocracy. This was Rosan Wallon and others discussed for a while. Instead, there's a Korean-German philosopher, Han, who calls it an infocracy, infocracy, and some even call it the infocalypse, so dying. The dominant practice is, again, excuse the language, to flood the zone with shit, to call a very infamous radical who organizes globally. The philosopher Harry Frankfurt described this in 1986 already, the book published, however, in 2005 and then started being read. It's called excuse my language, On Bullshit. More and more empty phrases, essentially nonsense, are coming into the world. And these are not linguistic games, as Wittgenstein would have it, but it is what I call the production of an ignorant society. More and more and more and more dumped on you, and you're kind of lost in information. What matters is then not what is true or fact. What matters is what you believe, what you click, what gets likes, what provokes a reaction, predominantly emotionally, no matter what. Ignorance, not knowledge, ignorance of anything becomes the sign of power. That's one characterization of this new totalitarianism, which is on the rise. And again, it is not a new strategy. It is only intensified by technology. To spread disinformation, well, they did it in the 30s and 40s. Big time, that's what Orwell and Arendt were concerned about. But it was way more visible then. There was a Volksempfänger, a radio. There was a paper most people read. There was a citizens' assembly or something. There was something which could resemble metaphorically a marketplace. But this is all gone. Instead, there are now still so-called social media, yet deeply unsocial bubbles of media technology and programming. You shall be totally absorbed in micro-targeted news. You do not share this epistemological ground with anybody, well, with your bubble. It works. Recent elections show, not only in the US, that muddying the water helps catch more fish, in this case voters, and votes largely cast on the basis of emotional appeal. And then, when the totalitarians take over, there is but a passing swarm of very small fish online. No pressure, no change. Where's that big protest? Well, it's maybe a romantic idea to still have that. Now you protest online in your bubble and you feel really like, I put the point down on this. Well, a swarm of little fish passing by. Is this too pessimistic a view? Well, it has at least many sensible people worried, some even scared. Akbar, the young Iranian, said so, but she's not alone. Say, people I not that often quote, the delegates at the World Economic Forum, Davos, agree. For the second year in a row, they consider disinformation the biggest short-term global threat, above war and weather disasters, an issue that did not even feature on the worry list before 2024. All over the world, these new totalitarians are up and running. However safe you may feel right now, don't let them fool you. You know the famous story of the frog put in water, heated up, starting to boil, so it will not jump, but die. Similarly, Madeleine Albright described the rise of fascism as plucking the chicken one feather by one, so it does not shriek too loudly, but is dead in the end. The ideology there, and the technique and the strategy is ethno-nationalist racist, heterosexist patriarchal, ruthless and greedy. It's called ultra-conservative by some, and they imagine society not anymore to be run by you, but again by a leader, for Germans a tricky term, the Führer. It's now called a CEO, maybe with a board, using effective technological control and profitable for some, last not least. If things go wrong, there's still Mars. So today, we are not beyond knowledge. We are not post-factual. There is no natural sliding into this state of affairs, and facts do matter still, but there is the anti-factual attack on them. There's counter-knowledge, alternative truth, and the new mark of power is to simply not care. And to avoid a misunderstanding, there is no golden era of truth back some time. We have no reason to romanticize the past. Truth was always contested, and there's no distanced, neutral objectivity. The history of science, in fact, is also a history of bias. This is what happens when you exclude women, for one. Luckily, critical epistemologies in gender studies, critical race, post-colonial studies, and more allow us to uncover that bias and understand the world much better. Also, postmodernism helped us understand, since Jean-François Lyotard's 1979 study, that the grand narratives out there were not necessarily true in that they left out quite a bit. But the point was, this was not an attack on truth. This was an attempt to enlighten us on additional aspects of the grand stories that are important in our worlds. The truth, Karl Popper and others reminded us on and on and on and on and on, the truth is relative and knowledge a living thing. This is, by the way, why higher education and research are at best engaged in collaborative skepticism. But others are interested in distraction, those anti-factual totalitarians. Some very rich people, organizations, companies, parties, governments, including presidents, have a keen interest in the loss and eventual irrelevance of facts, of objectivity, of shared epistemic standards, of this consented upon truth. Those who object are wrong, not wanted, the enemy, as US Vice President Vance called universities in 2021. Should I say that again? Well, they are the ones, not postmodernists, not critical thought. They are the ones who create the anti-factual challenge. They have been called merchants of doubt in the, ironically, marketplace of ideas at its best now, as unfair as it gets without regulation. They're aggressive, ruthless deal makers who produce their own truth and many truths for many, whatever you look for, and then simply do not care because it doesn't matter anymore. You can lie to anyone. You voted for emotional appeal, belief, you feel good. That's the point. These days, it works. And shockingly, very many people seem to have not much interest in participation, an exchange of arguments, deliberative democracy, and the like. Instead, isn't it much more comfortable to believe in something? To have somebody else take care of things? Enough to feel it to be true? A firm identity, be safe in my community, my bubble, no trouble. No discussion, please. Very tempting, very tempting. For sure, again, there's a paradox. There was never more knowledge, what Peter Berg called the knowledge explosion in 2012, but indeed, it's an explosion. There was also never less certainty or agreement on truth. Never have we had more expert committees, but many people at the very same time lose trust in science and in institutions generally. There is, yes, a rally around the flag effect when new problems come along and people kind of move to the leader with the flag, as during the COVID pandemic, but it did not last. All the studies show in the beginning, yeah, science, okay, follow the epidemiologists, etc., but that dropped to lower levels even than before the pandemic. And that's indeed a paradox. More information, but no informational socialism. Too many no reliable facts, much expertise, no truth. So that is what I call the anti-factual challenge, the crisis behind the crisis. No way for politics, or harder for politics, to reach consensus because we can't agree on what, only belief, assumptions, lies, no democracy. So what about the law? How does the law deal with this? What is the role of the law and legal institutions in dealing with beliefs, assumptions, lies, all charged with emotions running high? There are certainly many answers to this question. Law as such has knowledge dimensions. Legal knowledge is a factor in mobilizing law, and law itself carries information and produces knowledge, as via criminal law, in blaming people, etc., etc. Law also rests on knowledge as facts. Therefore, the more precarious the knowledge, the less reliable, the less protective, the less functional, and the less fair the law. So my point is that this crisis affects all realms of legal practice. Take regulation. For a long time, and broader than in some approaches in law and economics, civil law has been understood as being a knowledge distribution scheme. That is pretty much what it's about. Tort law attributes responsibility to know. The one who knows a risk or damage or fault or should have known has to pay, and those who are at an informational disadvantage may not be bound or obliged by a contract, even in marriage. Also, regulation distributes knowledge, and information is the lifeblood of regulatory policies. There are different modes of doing that, and in regulating risk technologies by obligations to know what is coming, take precautionary measures against it, very important environmental law, and many, many other things, regulating global trade, regulating the financial market, is all dealing with information. In addition, law seeks to produce knowledge when it attempts to incentivize innovation, like greening the economy. And there's even more. Or take the administration and the executive. Historically, the modern state developed hand in hand with knowing people, which is why Michel Foucault was so interested in knowledge and power. Population studies are still a tool of control, and the power of numbers is still out there big time. The challenge now is that there are so many numbers. So the numbers Foucault looked at, well, it was kind of clear. But now, what do? Again, the example of COVID. Low or high risks of vaccines, low or high infection rates, low or high death tolls, a flu or really something serious, all there, deliberately targeted, eventually anti-fact. Then the administration in those cases has to collect knowledge, organize knowledge, maybe also incentivize knowledge, expertise in government and sponsored by government, specialized branches to deal with knowledge, expert committees, agencies, research funding, they all have to deal with this. And there's more. Now what about the judiciary? How should judges handle this anti-factual challenge? How to deal with this world of beliefs, assumptions, lies, emotions? Emotions? Courts are not known to be into that. Instead, there are dimensions of the human experience that are excluded from trial, from proceedings, from courts' prevention, sometimes, by the way, to the detriment of people from the legal scene. There's very interesting work out there on that. Lies, well, courts are there to undo them when the perpetrator covers the crime, or the tort, or the witness lies. That's all fine. But these are what in studies is called adjudicative facts. These are not the general facts that are at stake politically in those big judicial review cases, but the adjudicative facts on the conflict at hand. Assumptions, courts are meant to replace assumptions with facts. No prejudice, but judicial reasoning. Evidence, proof to dispel the reasonable doubt that protects the presumption of innocence, etc., etc. This is why criminal procedure requires those who testify under oath in Germany to stick to the best of their knowledge, and it says in the law, to the pure truth. In the UK, in Canada, in India, and in South Africa, law wants the whole truth and nothing but that. It matters. It matters in civil law as well, but this is all the truth about adjudicative facts, the facts at conflict directly in the case. There's expert evidence law, etc., etc. Challenging as such, courts need to get these facts right. They search for procedural truth there. There are rules to limit discovery and the use of expertise, but also produce facts, etc., etc. Justice here requires just laws, of course, just administration, of course, but it also requires factual truth to get it right. Courts must find out what happened. Also, by the way, German law says that a judge in the German law on judges requires a judge should swear that they will serve but truth and justice. Accordingly, the German Federal Constitutional Court has held that the judge who does not seek the truth violates the fundamental right to a lawful judge and should be thrown out. Don't you also believe in that? Well, I tried to research the oath of judges, the judicial oath in English and for English and Welsh judges, and I found the allegiance to King Charles and the promise, to do right to all manner of people after the laws and usages of this realm. But I do really like without fear or favor, affection or ill will. That does include a commitment to stick to the facts, right? It's not explicit, but I assume it does. Well, whatever. Again, to avoid a misunderstanding, there is no reason to romanticize. Law is a human enterprise, it's a human endeavor, and humans may fail. It's also a site of power. Its institutional design may be unfair. Its practice may be biased. But the standard there is nonetheless justitia, sticking to the facts. So these are all adjudicative facts. Last point, judicial review. Now what happens when courts, they have a case that makes the case running, but then they have to assess whether the government was right, a statute is legitimate, the competences of the government were there, etc., etc. They must assess the general facts, what is called a general fact. So again, imagine you're a judge at a Supreme Court, at a Constitutional Court, at a Human Rights Court. New files come to your desk. You open them. You start reading. And there are studies on both sides, to attack the statute and to defend it. They look pretty much the same. How do you decide? I again remember it well. In my files in the court, in deliberations, there were studies and expert opinions as usual. But in the past, what looked scholarly was scholarly, reliable, and could be used. Debatable, for sure. There's no that one answer, but today that is no longer so. Previously, the court, as many courts in the world, consulted experts recognized in a field. But today, who is an expert? Some are real, some are fake. Who knows? The field is entirely fragmented, quality pretty unclear. How are we to know, since after all we are only lawyers, aren't we? Previously, all courts took in research by clerks, by the judges themselves, that produced additional basis to decide. Today, again, there's too much information. It's overwhelming. It's confusing. It's unreliable. The paradox I mentioned earlier is not elsewhere. It's also in a court building. It hits the court building. The enormous quantity and quality and speed of changing information online is a challenge there. How then is any judge, how was I, how would you, if you were the judge, how would you in your legal practice, in your research, etc., etc., decide that. This is not only an opportunity for self-reflection, for justice in doubt, and that's a good idea for any judge. It is a broader concern, I think, and a reason to worry. These facts that matter in judicial review are not called adjudicative facts, but very often called legislative facts, which I think is too narrow a term, so others call them general facts, and I will call them general facts. So it's the economic situation, the climate, the reason to go to war, the pandemic, migration, inequalities, all of that. And they do matter on two levels. A normative level, as normative updates, and a justification level. On the level of norms, these general facts inform doctrine and standards to properly address reality. Whoever interprets a constitution or human rights treaty, and words do matter, has to make sense of usually very few words, or even unwritten things, in order to deal with a pretty complicated world, and that world keeps changing constantly. So laws may be amended, but constitutions and international law is usually meant to stay, at least for quite a while. Therefore, it's largely on the courts to update our understanding of what these few words mean. If not, words lose their meaning. If not, courts lose protection. If not, people lose out. So it is, by the way, what radical conservatives want. They don't want an update. They insist on original meaning, a very plausible and tempting idea. Never mind that such original meaning is almost impossible to find. Instead, it is a tentative, most likely biased, ideological excerpt from a bigger, but often fragmented, always fragmented, and not fully documented story. Also, many have said lawyers are not historians. But even more importantly, the law loses meaning, and that's the important point, when thrown back into a distant past. No smartphones yet, no technology, no social pluralism, no cultural pluralism, much of what we live with today not yet understood. Thus, no meaning of these few words, not applied. Therefore, most courts and judges in the world reject that approach. Instead, they go by living tree doctrine or similar metaphors to make sense today of the few words in those old documents. It is only with such updates that constitutions and human rights can be applied. If not, no ruling. If not, the job of a judge not done, so you better update what you have in front of you. The task is to humbly, though, update the norm. At best, this is when facts matter. However, this is not the norm, because there's also well-established, legalistic, even fetishized, as Anger would have said, and tempting option, not when you update the norm, not to go for facts, but to go for an image, an ideal, a calling, a concept. After all, lawyers are neither historians nor sociologists, economists, climate scientists, migration studies experts, etc., etc. Thus, it seems much easier to interpret the few words of constitutions and human rights documents based on an idea, a concept, a guiding principle. That is the classic move. It is a mission statement then, a Leitbild, a Menschenbild, the image of the human, the subject, etc., in mind. You are, I guess, familiar with it. Liberty, well, that's a right of a man to autonomy. Equality, a right against arbitrary treatment. But both are pretty narrow understandings of these two few words, big clauses in constitutions. Normalities, the risk is normalities become the law, and those considered not normal lose. Take the reasonable man, an inadequate norm to judge a world with, for starters, men and women, and also more or less reasonable people, but a fascinating mix of empathy and ego, emotions and rational thought, a physis and a psyche, etc., move around. The reasonable man, really, nope. Take man or woman. Much easier to follow the very powerful bioessentialist idea as if the world would be clearly divided among the two, but definitely necessary to engage with the complicated spectrum of what we know about gender today. So to paint a legal picture with those few words invites assumptions of normality, belief, but also bias, so I think it's not a good idea. So the better idea, the alternative, is to take realism into account, to take facts into account. The better option is to go empirical. Only then may liberty or privacy protect what Germans call informational self-determination. I know it's pretty German, but you know, I mean, it's about your data, your smartphones, your computers. And we even call it the confidentiality and integrity of information technology systems. We want to be very precise. But the point is, it is an empirical understanding of what liberty and privacy and dignity must mean in this world today if I want to do anything as a judge. Otherwise I can, go home. Only then, if you go empirical, can speech, the press, broadcasting, whatever words you have, cover the digital dimension. It was usually not there when these documents were drafted. Only then does a fundamental right to family and marriage cover more than a heteronormative patriarchal model. Things have changed there. And it is only a skeptical, a critical, a well-informed searcher for facts that allows us to get a grip on varieties of sex and gender, as well as on body, health, way beyond physical dimensions, on disability, on chronic disease, things that were not on our minds or the drafters' minds or these parents of these big documents' minds. However, all of this becomes way more difficult with the anti-factual challenge. The other level. Normative change is also not the only calling. General facts are also important on the level of applying constitutional human rights law. If you consider this all a culture of justification, general facts matter and are decisive when you ask the question of whether state action is justified, whether a statute is justified, whether a government decree is justified, whether a government take of competency is justified. It becomes a justificatory element. This is indeed, I think, the bread and butter of constitutionalism. And again, imagine you're the judge. This is your job. This is your job. Yeah, apply the law and you have to know all the techniques and interpretation of the law and the wording and da-da-da-da-da. But you have to deal with these facts too. Something not as much addressed in legal education, and I get back to that point. When Supreme Constitutional and Human Rights Courts engage in judicial review to check whether the government or legislature was allowed to do what they did, or whether they went too far, they have to assess these general facts. It's what legality, constitutionally speaking, is based on. It's very often a matter of separated powers and competence. Imagine a national government that claims the power to handle an emergency situation. Say, send national troops. Oh, that's a very timely example. Or does something usually left to other authorities, be they local or be they international. There must be a reason to do so. What's the reason? The reason is a particular set of facts. You have to understand whether they are there or not, and you have to get it right. Imagine a government asking for special permission to limit your rights, like claiming a state of exception, an Ausnahmezustand, or going to war. There must be a reason to do so. No fake news, no manipulated information, no deception, but facts. You remember Iraq, right? And facts are also, that was competencies, a matter of fundamental rights. When courts are called upon to decide whether rights are violated, they need to know why something was done, what it does to people, whether there are less intrusive alternatives, and whether everything that matters was properly balanced. Proportional, in short. Your liberties, your equal rights, it's the job of Supreme Constitutional and Human Rights Courts to review whether a majority in power did something to you that went too far. And the question is, did they have good reason to do so? Yeah, complicated legal standards, etc., they differ. But there is a side to it that is factual or fact-driven. Courts then assess proportionality, and proportionality is all about facts. The fit between the measure and the goal, the necessity of the intrusion, alternatives, etc., etc., etc. In my experience, this is always a challenge. Again, it is not new, but it intensifies with the anti-factual world out there. Think of the government going to war and to find the facts. Think of climate, all entirely controversial. Think of COVID and other pandemics like the bird flu. Think of, sorry to say, Brexit. Think of gender, not a question of morals or everyday norms or ideology, but facts matter. Think of migration. These are not just controversial issues. They are deep in muddy waters. Populist narratives overshadow legal analysis. People party in front of courts There's not just disagreement, but there's lots of disinformation, there's misinformation, there's lies. It's funded, it's organized, it's not just, something, and we get over this. This is more than that. So when courts are portrayed as taking sides in truth disputes, depending on what they say, when courts are then called elitist, not neutral, part of the system, sometimes even enemies of the people, simply getting it wrong, ideological, overly activist, this is an attack on courts, institutions, the rule of law, yes, but it's also an epistemological point they're making. They didn't get it. There's another truth out there. They're wrong. That's worrying. So what are we to do about it? I think there are 2 points, the last 2 points. We need to revisit the role of courts. Oh, there are many answers. But you're all academics and have time, and you do that, right? And you're lawyers, and you do that, right? So, but to start, and really it's a start. I think it's a difficult question, and there are no fast, quick answers. It's a start. So 2 proposals. We need to, I think, revisit the role of courts, tasked with judicial review, and legal education. Wasn't there? Well, legal education. There was something there, and I'm happy to say that at LSE in particular, you're going to understand why. So, role of courts. What are courts epistemologically? Interpreters of law, sure, but what about the facts? What is the role of courts regarding knowledge, expertise, the truth? There's literature out there, there are proposals. Some see them as arbiters of truth. At least in adversarial systems, some call them referees. But I think constitutional justice is no soccer game. Some call courts the last bastions of reasoned justification of public matters in the public sphere. Indeed, constitutional and Supreme Courts, I think, are guardians of epistemic integrity, particularly when they demand reasons and access to them. Courts then become stewards of truth-based governance. That's what ChatGPT said. Well, at best, they demand transparency, rationality, and accountability from state actors. So they have a role to play in that whole knowledge game. They force governments to inform and not lie to parliament. It's a very good idea not to second guess and then play the thing back to parliament and politics. But I think this is not enough. I think courts also these days have a role in combating information, disinformation, and uncover lies in bigger ways. I suggest that to think of courts then as facilitators of a discursive truth and as communicators of what is accepted as fact and why. Judges do not know it all, and they never will, but judges have a job in curating expertise, in curating facts, and a job in exposing why what can be accepted as fact and why some things must be rejected. So much communication there, facilitators and communicators. Consider examples. I'm sorry, it's hard to say that when Brenda Hill is sitting here, but is the British prorogation case an example where this could be rethought and applied? The ruling of the UK Supreme Court in Miller 2 has many dimensions. However, it may also be read as countering deception and misleading pretense. The government claimed the prorogation was routine, but other information and timing suggested otherwise. It was a legal decision about an ideological fight, sure. Did the ruling address that? If we revisit the ruling, is there a role for the court to address that, to discuss that, to do more? Later attacks on the judges give rise to deep concerns. So what are next time? What are courts to do in preventing that and responding to that, etc., etc.? Another example, maybe the German climate ruling. The files landed on my desk in 2021. It was considered now a landmark decision because it introduced a temporal dimension of liberty, which is the intertemporal guarantee of freedom. Plaintiffs were rice farmers from Nepal and Bangladesh, children in Germany, heirs to a North Sea farmstead shrinking because the sea level is rising. The question was simple. Did lawmakers accurately assess climate change and their situation? And did they do enough to prevent that harm? Thus, an assessment of general facts. What about the climate? What are the adverse effects to who? What's the reason? What can be done in response, etc., etc.? All dimensions of climate studies were on the table. All of them mattered. And all of them were at the very same time attacked by many, many, many actors out there. For some, it's natural science and hard data. For others, it's conspiracy or simply all wrong. The role of the court? We felt the need to spend more time than ever on pages discussing facts and peer review standards and the quality of facts. Not just restate the facts, but tell people why these facts are acceptable and others not. Is that one way to go? Maybe. COVID is certainly another example with additional dimensions. Like many other courts, the German court received hundreds of complaints, reviewed them all, etc., etc. Clearly, there was a viral infection. Clearly, many people were falling ill, and many people died in Bergamo, in New York, in German care homes. But even in the face of death, the anti-factual challenge was louder than ever. My files both presented data, studies, articles, books from professionals and academic associations. What were we to believe? Everything was contested. Everything was emotionally charged. Everything was polarized and is still polarizing. Science-driven politics or the dangerous deep state? To complicate things, this was not only about facts, but this was also about risk assessment, a prognosis based on facts, changing daily. So it was even more difficult to handle that. The court invited experts, as diverse as you can get, including the so-called experts, Doctors Against Vaccination, a populist group. Did the ruling do enough to expose that? Did it facilitate and communicate facts sufficiently? It's on you to judge, but it wasn't, I'm describing attempts to upgrade kind of what they're doing. Or think migration. We know that people move across borders. They migrate to Europe, to Britain, but why, how, where to? Extremely controversial, emotionally charged, polarized, polarizing, rife with disinformation and misinformation, manipulated stories, lies, everything on the table. No coincidence, because the new totalitarians use particularly that topic, migration, to trigger rejection and hate and destabilize democracies. What is the role of courts then? It is tempting to work again with assumptions, ideals, or images like the refugee. And when I say that, what's the image in your head? Who is that person? What does it, gender look like, come from, status, economic situation, etc., etc. There is something there. And lawyers are very trained to use that with, leading cases and da-da-da-da-da. But I think to go empirical there is crucial to deliver justice in these situations. As long as the rule of law is the grammar of democracy, facts do matter. Note that academic studies of the topics I mentioned are all targeted by the new totalitarians. If you engage in research, you face a problem. You face an enemy because you are, to some people, the enemy. Such studies are denounced and dismissed for reasons. Are courts then even more important as facilitators and communicators of facts to counter such prejudice, lies, last not least, hate? I think so. Some may certainly object. If we assign this role, facilitating and communicating facts, to courts to counter that challenge, that is, to do more, doesn't it again strengthen and intensify judicial review? I'm looking at Martin, sorry. Activist jurisprudence, depoliticizing effects, an additional reason to reject new constitutionalism. Isn't that a threat to democracy? Courts again? Should courts defer then in epistemological matters? That would be one proposition. I think it's not a good idea. Here's, I think the broad call for deference, which is, by the way, the key element in things like attempts to reform, but in fact undo the Supreme Court of Israel, throws the baby out the tub with the water. Is that an expression in English? Well, throws the baby out the tub with the water. Certainly, courts must protect and cannot replace politics. They are reactive institutions anyways, equipped only with words, so it's not for them. Democracy needs room for politics. Courts are called upon to safeguard this room, open more room, etc., etc., etc. But if there is this challenge, this is all no carte blanche on governments to lie or to deceive anyone. Think of security matters, the Secret Service, diplomacy, international relations, military strategy, and war. Leeway, sure. Margins of appreciation, yes. But no carte blanche. It's no reason for government to lie to anyone, mislead anyone, manipulate anyone. So we have good reasons, I think, when we address judicial review to reconsider the scope and intensity and degrees of judicial review. That's for sure. For a long time, courts gave governments the benefit of the doubt. You did not challenge what the government presented to you because you assumed, I mean, they will not lie to you, others may. You know, those NGOs, doubtful actors. But government was right. I think we have to reverse that, particularly in international courts and human rights courts. You have to reverse that. States will try to mislead you. Think of Hungary reforming the courts. It was in fact destruction. Think of Poland under peace. There was no reform. There was an undoing it. Think of Russia in military operation to cover warfare, to cover ruthless aggression. And there's more. There are more examples of that. So no benefit of the doubt. So checking on facts. You cannot believe anymore what people say. Final point. Are judges fit to do that? Sure. I mean, wouldn't some of the people in the audience, bench people, agree? But really, what do judges know and what should they know? Legal education matters. If ever you need an argument, the knowledge crisis, it is why law schools are at best not just training camps for lawyers, but engage in legal studies, at best doctrinal and interdisciplinary as well. Facing the anti-factual challenge, legal education has to make sure that future lawyers and judges are up to these new challenges. I think it means inventing a new course. When truth is precarious, when facts are confusing, when data may be fake and knowledge is manipulated, all intensified with AI, to judge means to navigate well through this sea. So if we want to take facts seriously, we need to learn how to do that right. Future lawyers need to learn how to facilitate and communicate what can be accepted as facts and what must be rejected as flawed, false, misleading. It's more than the class in evidence. It's way more than the class in evidence. As far as my research went, it's not a regular course there. Not here, not at least in other schools. But maybe something. And there's knowledge out there, luckily. Criminology helps, forensic science helps, because they all deal with those things. Many other things help. Socio-legal studies help, gender studies help, critical race studies help, etc., etc., etc. Because judges should know about the things they address as factual situations, and they should certainly know about the general arguments in those highly controversial matters that are brought before them. So I think it is on all of us to counter this anti-factual challenge. As much as legitimacy in law and democracy depend on communicative reason or consensus on truth, it is a prime target for these new totalitarians, and this is why they denounce universities, this is why they attack the legal system, but I think we can fight back. LSE can fight back. All of you can fight back. So I end with another quote from the young Iranian, Noureen Akhtar. She asked the question, what is justice in a post-truth world? Not any longer Justitia, the blindfolded figure standing fiercely over a pair of scales, but now trying to see through the digital smoke of deceptions, masters facts and noise masquerading as knowledge. Then she says, legal systems too are vulnerable. It was once the courts, anchored in practice and precedent, but now it's courts having to deal with deep fakes, viral disinformation, and populist pressure. But, she says, justice is not dead. It is growing as a way, changing as life does. The world of post-truth calls for a more explicit and reflexive kind of justice. Justice must once again become a mode of listening, of bearing witness, of reconstructing trust brick by fragile brick. It must insist on the possibility of understanding and to affirm the dignity of truth in the face of its erasure. For even when truth is obscured, its pursuit remains the most radical gesture of hope. Thank you very much. Thank you.
Thank you so much. That was very special. It started with perhaps the best word to start a lecture, imagine, and then it ended up with the perhaps best word to end the lecture, which is hope. Everything in between, lucid, searingly powerful, and very, very urgent. Thank you so much. I was, not to drag the tone down too much, but with your anti-factual challenge, I kept being reminded of the writer Aaron Sorkin's most famous line before The West Wing. The truth, you can't handle the truth. But Susanne, you've displayed beyond all peradventure tonight that not only can you handle the truth, but you can handle half-truth and untruth too. Thank you so much.